Oh, Jesus Christ.
All right. Well, good afternoon, everybody, and welcome to this webinar sponsored by the Lafayette Chamber. But this one is really not about the Chamber speaking to you. It's about, we're real pleased to have a very special set of guests that are going to help us all navigate this uncharted waters. My name is John McCormick. I'm president of Lafayette Chamber Board this year. And on behalf of the Chamber, I'd like to welcome Angela DLHA and her folks at the DLHA Law Group, and they're going to be going through some items they have, plus answering some of your questions. So I'd like to turn it over to Angela, and she's going to take it the rest of the way. Angela.
Thank you. Thank you so much, John. Well, good afternoon and welcome to the webinar. We're happy to be here. We've been navigating this water ourselves now for a little bit of time. As John said, my name is Angela DLHA, and I head up the law firm of DLHA Law Group. We're located in Walnut Creek. We have an office in San Francisco and Los Angeles as well. And when COVID broke out, we were surprised like everybody else. And when the shelter in place order went down in Contra Costa and San Francisco counties, we realized that a lot of our clients would be impacted, and we started getting calls right away. So we amassed a task force made up of the people you see on this screen, other than Holly and John, to take a look at what business owners and companies could do to get out ahead of this as much as possible and regain the driver's seat so that they could see their businesses through and hopefully stay in business and manage their employees effectively. It's been a very difficult time for many, many people. So we've tried very hard to stay out ahead of the new regulations, ordinances, statutes, and on the federal level, of course, the CARES Act and the other legislation that is coming down the pike. And that includes also taking a look at the different laws and benefits that are afforded to employees. So with that, I'm happy to kick off the seminar and introduce our panelists and our team. We have, they're all from our firm. The first person that will be speaking is Lindsay Meyer, and she's our employment law attorney at the firm, and she will be addressing the different issues that employers face in managing through this and guiding their team. The next person that will be speaking will be Christina Romero, and she's our compliance attorney at the firm, and she will be speaking specifically to disability and unemployment insurance issues. I know there's a lot of questions about that, and I know a lot of people are trying to apply. So the next, we'll have Jackie Menendez. She does litigation and employment support at the firm, and she will be speaking to the health and safety of employees and specifically addressing paid sick leave and the Family Leave Act. And last, we have Kellen Stevens at our firm, and he's our senior transactional attorney, and he'll be speaking to the financial viability issues that businesses face, including the CARES Act, the PPP loan specifically, other issues as much as we can within our time frame that include things like what to do about leases, commercial leases, loans, obligations, and vendor obligations as well. So with that, I know we don't have a lot of time, but we're going to cover in a general breadth those topics and take questions and answers at the end. Because we are not.
I'm sorry, I should, before I forget, because I want to make sure, we want to thank everybody for filling out the survey. They gave us the questions. Also, if you have any questions you think of during the meeting, feel free to put them in the question and answer box. I want to make sure that was brought up before.
Yes.
At the very beginning, and then they'll be answering some of them throughout the session. Sorry,
Great.
Angela, go ahead.
Yeah, that's okay. So yeah, we will be looking at the question and answer box as we go through. And if we don't get to all the questions, we're happy to take a look after the webinar is finished. We're lawyers, so I have to add that this is not legal advice. If we were giving you legal advice, we'd probably be on the phone with you or have you in our office and be able to ask you a host of different questions and, clarify with specificity your particular issue and be able to give you very personalized advice. In a setting like this, that's rather impossible, but we'll give you our best breadth of legal knowledge and encourage you to seek legal counsel if you have very specific questions. So with that, let me introduce Lindsay Meyer. As I said, she's our employment law attorney.
I don't see myself on video. Can you hear me? Because my video is not starting.
We can hear you.
Can you see me?
No, but we do have your slide up if you want to walk through the employee term.
Well, all right. Okay, I apologize. I'm not sure why my video is not coming up, but thank
Lindsay,
you all for being here with us today.
You can go ahead and enable your video right now if you want.
Okay. All right. Okay. All right. Hi, everyone. Sorry about that little technical glitch. I'm going to be speaking about employee terminations and furloughs today. It's come up, unfortunately, because of the current pandemic. A lot of employers have been faced with the hard decision about whether or not to reduce their workforce. When that decision has to be made, employers have been coming to us asking, what makes the most sense? Should we do layoffs, which are essentially terminating the employment relationship, or furloughs? And what's the difference? The main difference with when you are furloughing an employee is essentially the intent. It will be the intent of the employer to bring that employee back when they're able to do so. Depending on whether or not you furlough or terminate or lay off employee, I should say, because of the need to reduce the workforce, will have an impact on the employee benefits. Specifically, if you furlough an employee because the intent is to bring them back, generally employers are opting to continue the employee's health care coverage. Now, if the employer has the employee typically make a contribution each pay period, then the employer will have to decide under these current circumstances if they're going to ask the employee to continue making that contribution while they're on furlough, or if the employer will cover the entire amount. If the employer is not going to continue the healthcare benefits, then it's really important that the employer still provide all the required COBRA notifications to the employees. Regarding sick pay, and we will discuss sick pay in more detail because there are a lot of laws that have changed recently because of the COVID-19 situation. But if you furlough or lay off an employee, if they are not otherwise entitled to sick pay under the law, you do not have to pay them out any of their accrued unused sick pay at that time. Vacation time is a little different. If you are going to furlough an employee, it depends on the duration of the furlough. If you lay off an employee, then any accrued unused vacation or PTO that is on the books for that employee needs to be paid out upon the time the furlough at the time the layoff is effective. Now, if you're going to furlough an employee, the Labor Commissioner's Office has provided some guidance to employers about when they are required and not required to pay out any vacation time on the books. And it's long been the division policy that if a shutdown does not exceed 10 days and there is a definite date given for return to work, then that employee is not considered terminated, and therefore none of the vacation needs to be paid out at the time of the furlough. Of course, that's a very short furlough period, and a lot of employers are having to furlough for an indefinite period of time at this point because it's just uncertain when they can bring people back in. The Labor Commissioner's Office gave further guidance, and they clarified that if an employee is laid off without a specific return to work date within the normal pay period, the wages earned to and including the layoff date are due and payable in accordance with Labor Code Section 201, which again encompasses any vacation or PTO that's on the books. So if you're going to be strictly following the guidance provided by the Labor Commissioner, if you are furloughing an employee and you cannot give them a specific return to work date within their normal pay period, then they are advising that you pay out any vacation time, any and all wages due, which would include vacation time. And that has been a really big question that's been asked by many of our clients, so I wanted to cover that one in detail. Now, there are alternatives to furlough. There are, you can do a reduction in hours. Employers have been asking, can we do that? Yes, you can. Just be aware that employees are allowed to apply for unemployment insurance benefits if that occurs. You also can do a reduction in pay. Now, if you do a reduction in pay, I would just there's many things to be cautious about, but primarily just make sure that any wage reduction is only being applied to hours worked after the reduction has gone into in effect per the notice you give. So you can't essentially backdate any reduction. I think that's probably obvious, but just that's a question that's come up. And also to avoid creating any contractual obligations, when employees ask, when is this going to be over? When can I expect my pay to go back to what it used to be? I would not give them any guarantees about when or the amount the pay of increase will occur, just to avoid creating any type of contractual obligation about the timing or the amount. Now, lastly, I just want to touch on the California WARN Act. For those of you who are not aware of what that is, it stands for the Worker Adjustment and Retraining Notification Act, and it essentially applies to employers who are going to be doing significant layoffs, so 50 or more employees. All the requirements are still in effect regarding the WARN Act. However, the Labor Commissioner's Office issued an executive order recently that suspended the strict 60-day advance notice requirement that employers had to give if they were going to be laying off that many employees. So that's just something to be aware of. If anyone has any more specific questions because they're anticipating doing mass layoffs, please feel free to ask that question. But that wraps up my piece, and I'm going to go ahead and pass on now to Christina Romero, and she'll be discussing short-term disability and unemployment insurance. Thank you.
Thank you, Lindsay, and thank you to everyone who is here attending with us today. As Lindsay mentioned, I'm going to do a brief overview of short-term disability and unemployment insurance. So to begin with disability, disability claims and benefits are available to those eligible workers who are suffering from either full or partial wage losses due to non-work related injuries, illnesses, or pregnancies. Now, California has expanded this disability eligibility to cover those who have been exposed to COVID-19. So in order to qualify for the disability benefits, if you have a worker who has been exposed, they would need to receive the certification from a treating medical provider that would indicate their exposure to COVID-19, and this would be sufficient certification to apply for the eligibility benefits. They can apply online at edd.ca.gov, and in terms of benefits received, it's roughly between 60% of their wages, just depending on their income. Lastly, Governor Newsom did pass an executive order March 12th that waives the 1-week waiting period to receive these benefits. In addition, that 1-week waiting period also applies to unemployment insurance, and so I will now jump into that. You know, unfortunately, again, as Lindsay mentioned, it's the reality of our economy is many employers are faced with the harsh decision to have to let go their employees, whether through a furlough or whether permanently. This is just where a lot of our businesses are at, and a lot of clients have come to us with this problem. And so if they are laid off and they're laid off through no fault of their own, they can qualify for unemployment benefits. So California administers unemployment insurance. So I'm going to go through just traditional unemployment insurance and then the federal expansion through the CARES Act that was recently passed. So generally speaking, unemployment insurance is for 26, it covers the 26-week period, and is administered by the state of California. They can, if you're eligible to apply, you can apply online, again, also at edd.ca.gov. The 1-week waiting period has been waived, but because there's just been a backlog and an overwhelming number of applications for unemployment insurance, people aren't seeing the benefits right away. So which I know this is frustrating. People have, you know, families to take care of, and the way that the government has addressed this is that they're going to backdate it to the date that you become eligible to receive the claim, rather the date that your application is processed. So just you know, hold on and keep patience, and those benefits will come in. So moving on to the federal expansion, there's 3 different expansions. The first one is an extension to the 26-week period. It's an additional 13-week period. And so when that kicks in, it looks like you'll, once you have used up the 26 weeks of benefits, you'll automatically be converted to the 13-week extension if needed. And the second part of the Federal CARES Act expansion is called the Pandemic Unemployment Assistance. There's been a lot of information about this in the news. This has been created, it's a brand new program, and it's really meant to help those who are working in the gig economy, specifically those who are business owners, those who are self-employed, those who are independent contractors. So people who are not generally eligible to apply for traditional unemployment insurance. So when filing the claim, and actually the application just became available yesterday, also again at edd.ca.gov through their unemployment insurance claim. There's not a specific or a separate application, rather you would go through the general unemployment insurance claim online, but they'll have a different subset of questions for you. And so in order to qualify this, you'll need to certify that your employment status, you're self-employed. And in terms of benefits, that will run up to 39 weeks, starting from February 2nd, 2020 through December 26th at the end of this year. It just depends on when you became impacted by the pandemic. And the amount received through these benefits will be based off of your previous income. So you'll also need to certify and submit documentation of your previous income. So moving on to the third expansion, which is the Federal Pandemic Unemployment Compensation Program. And this program is the additional $600 of federally funded benefits on top of other benefits received. So this would apply both if you qualify for unemployment insurance or the Federal Pandemic Unemployment Assistance Program. That $600 will be added on top of your weekly benefits. That has been rolled out and people have been starting to receive that. And so that wraps up my section. So if you have any questions, of course, feel free to ask in the Q&A at the end or contact us directly. I will now pass this over to my colleague, Jacqueline Menendez. She's going to be covering paid sick leave, paid family and medical leave, and how to keep employees health and safe. Thank you.
Thanks, Christina. Hi, everyone. As Christina mentioned, I will be covering sick leave, paid family leave, and employee health and safety. So first, regarding paid sick leave, Congress passed the Families First Act, which provides for expanded paid sick leave and family leave obligations. This law went into effect on April 1st, and it's effective until December 31st of 2020. So now employers with fewer than 500 employees must provide up to 2 weeks of paid sick leave at full pay when the employee is unable to work because of reasons related to COVID-19. This includes full-time and part-time employees. And employers must provide notice of these new requirements to current employees. This notice is available on the Department of Labor's website, and the posting must be put somewhere that's visible to all employees. And if employees are not in the office, then the notice should be emailed to those employees that are teleworking. And the notice must have been posted by April 1st of 2020. Now, in regards to family leave, the biggest change in the law is that now an employee who is caring for a child whose school is closed or where childcare is unavailable can qualify for family leave and receive up to 2 weeks of paid leave at 2/3 of the employee's regular rate of pay. And in addition, if an employee has been employed for at least 30 days, then they may qualify for up to an additional 10 weeks of paid leave. However, if an employee is able to work from home, then they can't use paid family leave. These issues are very fact specific, so we recommend that you talk to a lawyer about the specific circumstances individually. Many of these issues hinge on the classification of an employee, and that's why we recommend that you speak to a lawyer. And in some respects, the law is still very unclear, and there are rumors that there will be a legislative amendment to clarify some portions of the law. Now, many of you may now have employees that are working from home, but when employees come back to work and are physically entering the workplace, employers can ask employees if they have symptoms associated with COVID-19 or if they have been tested for COVID-19, because the WHO has now declared this a pandemic. However, these questions posed to employees must be limited in scope. So for example, an employee or an employer may ask employees if they have a cough, sore throat, fever, or chills, but they have to make sure that these questions are specifically related to symptoms associated with COVID-19. And they must keep any information about their medical status as a confidential medical record that is kept separate from the personnel file in order for employers to stay in compliance with ADA guidelines. And if an employee is working from home and they are not physically interacting with employees, then an employer is not allowed to ask these types of specific detailed questions. Now, employees themselves may not be sick, but they may be caring for a family member with the coronavirus. And employers cannot ask whether their family members have the virus, but they can ask if they have been in contact with anyone that has the virus. And it is better to ask this as a general question because it is against the law to ask medical questions about an employee's family member's medical status. So that's all for my segment, and I'll hand it over to Kellen Stevens, who will be discussing economic relief and controlling costs. Thank you.
Unmute. Yes, we're all learning how to deal with this during the using Zoom. Thank you, Jackie. Thank you, everyone else, for presenting earlier. Basically, I'd like to talk about three different things. One of them is financial aid. The second is contract modifications or amendments. And lastly, it's contractual relief. So for businesses, clearly for small businesses, we're focusing on the CARES package that had two components, the Paycheck Protection Program and economic disaster loans. Unfortunately, economic disaster loans are out of funding right now, and the SBA is not accepting new applications. But the Payment Protection Program was refunded with an additional $310 billion as of Monday when they started accepting applications again. The Paycheck Protection Program is the preferable loan that you would like to get because it has a forgiveness portion, which basically allows 75% of payroll costs to be forgiven during an 8-week period, and 25% for other costs, which can include mortgage interest, rent, and utilities. Now, this applies to any small business, so less than 500 people, and sole proprietorships, which is really important. However, just to be clear, if you're a sole proprietorship, you can only apply for a PPP loan, or you can choose to get unemployment, but you can't do both. And so it's important to weigh those two risks, what you would be getting out of it to make a decision. California also offers a disaster loan program through California's infrastructure bank called the iBank. They have pretty good terms too, pretty low rates. They have some more extensive underwriting that's required. The Paycheck Protection Program had very limited underwriting. It was basically submit the application with the documents proving your payroll and your business and make a lot of representations about your need. So that's really all that was required. However, the banks weren't really equipped to handle the amount of applications. The SBA wasn't equipped to handle the amount of applications coming through the banks to them. So there's been a lot of difficulty in applying. And so we just recommend to continue to do that, to reach out to multiple banks, to try to develop a relationship or rely on a relationship that you already have with your banker. The next thing I want to talk about is controlling costs. And it really comes down to contract modifications. And I am sorry, one second. I just got a timeout, but I think everything's working on my end. Okay. Let me know if you can't see what my slideshow that's still up.
No, it looks good.
Okay, thank you. So basically, the two types of common contractual amendments or modifications we're seeing are people that have either leases, so they're tenants in a commercial lease, or they have loans, and whether it's like a credit facility or it's a credit facility, or a term loan. And clearly in both of these instances, to the degree that you're affected by COVID-19 and your revenue is drying up, you might be unable to pay rent or unable to pay on the terms of the loans. In both of these instances, we recommend talking to your lender or your landlord early and often. You want to tie any request that you have to COVID-19 and the economic suffering that your business has incurred because of COVID-19. And so for a lease, we're kind of looking at things like you can talk to your landlord and ask for abatement of rent. You can ask for deferment of rent. You can ask for an extension of the rent, or you can kind of get creative and say, look, if you're going to have me be a tenant and pay during this time at the full rate, maybe I had considered some like tenant improvements. Would you be willing to take on the cost of those improvements with me or share a greater cost of those? So depending on the lease arrangement that you have, there are some more creative solutions that we can implement with your landlords. When it comes to lending, if you have any term loans or credit facilities, we just want to be very careful about, you want to read your loan document and say, okay, it's not just about paying on time, but like, do I have any financial covenants? A lot of them say you have to maintain a certain amount of net income. And if you don't, then you're in violation and there's a like small d default and you have to notify your lender. See if your loan agreements say that, and make sure that you're communicating with your lenders. The very good thing about this is that lenders were advised from the federal agencies that oversee them to make loan modifications to the maximum extent possible, and to work with the borrowers, and the lenders themselves wouldn't suffer. Their credit ratings wouldn't suffer because they were making these modifications, which is what they were primarily concerned about. Finally, looking at, there's the financial aid, there's the leases, and lending, and then finally there's just contracts, right? Like your performance within a contract. Some of you might be familiar with the term force majeure, which is kind of the act of God clause that excuses performance under limited circumstances. Don't really rely on these. Over time, businesses have worked to kind of de-teeth these and make them less available for within the contract and less useful. So it's really only if there's like an act of war or a flood or an earthquake. Sometimes if they don't specifically cite a virus or a pandemic, you might not have access to it. And even when they do, what we've seen in certain like loan agreements is that there is a force majeure, but it doesn't excuse your ability to pay. It just excuses the lender's obligations or some of your other obligations. So it's just really important to read your contract. There's also these ideas of like, well, if your contract is completely frustrated or it's impossible to perform, you might be able to use that as a way to get out of performance of the contract. That's a very fact-specific inquiry. And so if you find yourself in a situation where you're obligated to do something and you can't do it, and the reason why is because of the pandemic, then you really do have to kind of look at the facts, look at what it says in the contract, speak with an attorney and find out, okay, is there a way that we can get out of this that will be cognizable before the courts, and that's understood with kind of basic contract law. Then again, these are all very, very fact specific, which is, it's unfortunate that it requires that, but that's definitely, it's what's required in these times. So I think that's it. I wanted to just give you the brief overview with the aid and the modifications and amendments. I know that Angela is the host, and thank you so much, Angela, for hosting with John. And maybe we can move into the Q&A and kind of get to the meat of the questions.
Absolutely. Thank you, Kellen. So with that, let me go into some of these questions. We also had some questions that were sent in earlier. And I think what we'd like to do is take one of the questions that came in earlier that had to do with employment, because as we see from the daily briefings from our governor at noon, and as we see in the news, it looks like the state is getting ready to implement a set of strategies for going through phases of a rollout of going back to work and opening up the economy. And that is wonderful. It will jumpstart things, but there are some other issues that come into play for employers as we start to go back to work. So one of the great questions, and we're actually setting up another webinar about what to do and how to manage getting your company back up to speed and bringing people back on board, bringing employees in. So one of the questions that came in was, what do I do if an employee is sick? And it's a general question, but we like general questions because we can drill down a little bit. So I'm going to ask Jackie Menendez to answer that question. And then most of the questions that came in online and also in the Q&A, we had a couple questions, are fiscally related. So we'll send those to Kellen afterwards. So with that, Jackie, do you want to address that question?
Yeah, thanks, Angela. And thanks for the question to whoever sent that in. Now, it depends on what type of illness the client or if the employee comes in with. So if they have symptoms of coronavirus, then of course you want to be able to send them home because they're posing a danger to other employees that are in the office. Another thing that employers can do is make sure to keep really the cleanliness of the office space just have a policy in place to make sure that every morning surfaces are being wiped down, that if it's possible for people to wear masks, and really have the policy laid out for the employees so that everyone is on the same page about what the restrictions are, like making sure that there's like 6 feet of distance between other employees. But really, it's a fact-specific question, so it depends on the symptoms that the employee comes in with, and really employers should try to minimize the risk by doing everything that they can to set the policies in place so that employees don't infect one another with the coronavirus.
Great, thank you so much. There was a question that came in earlier from a woman in Lafayette who was a sole proprietor and a college administrator. Kellen, I think you saw that question. Do you want to go ahead and take that one?
Yeah, I was just going to say that as a sole proprietor, most of these loan programs are open to you. And that, like I said, you just have to distinguish if you're a sole proprietor, you can't be receiving unemployment checks and also getting PPP, which would theoretically cover your payroll. Now, as a sole proprietor, you might not have payroll. What you do is you file a Schedule C and you have your net income, but you take that, you divide it by 12, and that gives you your like 1 month of payroll that you can use when you apply for the loan. And my understanding is that when you're going through the loan application, you submit those documents and it kind of like, it figures it out for you, right? You know, like, okay, take your income from the last 12 months, divide it by 12. This is what your payroll is because you're just a sole proprietor and you're filing a Schedule C. Now that's different for a corporation, which actually ties into one of our Q&A questions. Someone had asked, well, if we're a corporation and the owner is applying for unemployment, can we still get our PPP loans? And the important distinction here is that a corporation is a separate entity from the individuals. So the entity itself is applying for the loans, and then the people that work there are applying for unemployment. So the entity can still receive and apply for the loans, and that shouldn't be a problem with the PPP process because everyone is a different entity. So that shouldn't be an issue from a corporate perspective.
Great, thank you. The other question is, I'll take the one that came in at 12:31. It seems very unclear from the SBA, differing paperwork on their website, about when you have to start hiring staff back with PPP money, which is cool. We've seen the application. If your business is closed, it seems like a waste of money to pay people if they can't work. Some paperwork makes it seem like you have until the middle of June to hire people back.
Right. It said that you basically, you don't have to hire people back to get the loans. You have to hire people back and make sure their salaries aren't reduced by more than 25% in order to get the forgivable portion of the loan. Otherwise, it's just a loan, which are very good terms. I think the original interest rate was 1%. So that's below the rate of inflation, which means that your principal is getting eaten away every year. So that's a very good loan to have. But in order to get the forgivable portion, it's okay if you laid people off, but you have to hire them back before June 30th. And exactly how that works in the mechanics, the bill wasn't clear, and we're still waiting for some guidance. So the SBA and the Treasury Department issues guidance, and they did like one on April 3rd, I think, that clarified some ambiguity, because basically this is just legislation that is rushed out. And so we're constantly waiting for guidance. So they say, hey, you can hire people back until June 30th and still get a forgivable portion. And so right now, just focus on that. Like, okay, they said if I hire people back, that portion can be forgiven. And so that's what you have to focus on. Did you want me to jump to the next one, Angela? I can. Sure. So Elizabeth asked, and this is Graham. So this is a great question, and she asked for the difference between abatement, deferment, extensions with respect to leases. So an abatement is when you reduce the rent that you owe. A deferment is when you still owe the money, but you choose to pay it at a later date. And an extension is just extending the term of your lease, right? So if it ends in January, it's going to end in June instead. And then there's also a blend. And so what we try to do is when we're working with a commercial tenant that is having difficulty paying rent, we want to send a letter to the landlord, say, look, identify the cause, COVID-19. That's very important to always put that in writing, that this is the reason why. And then you can open up the discussion about what works for them. Because as a landlord, they also don't want to lose tenants that were otherwise good tenants and paying rent on time because of COVID-19. Because once this ends, they have to go through the process, which is expensive, to get a new tenant involved. They have to vet them. They have to underwrite. So they would rather keep someone that they already like. And so to do that, we think about, okay, could you maybe reduce my rent and we can waive a portion of the rent, 25%, 50%. Or we could agree that I'm not going to pay rent now, but I'll owe 2 months of rent in 6 months, right? So it's like a balloon payment at the end. And another alternative is you can agree to one of those two things, and then you also extend the term of your lease. And so that lets the landlord know, hey, I can't pay you now, but I'm willing to pay that difference in later in time in the future. And I will contractually obligate myself to do that by an approved extension of the lease.
Great. Thank you. It looks like there's another question. In order to qualify for the PPP loan, do you have to have an SBA loan?
Yeah.
Great question.
Yeah, that is. So the SBA works, there are SBA lenders. So you have to apply through an SBA approved lender. Now, the SBA approved lenders, there's a lot of them. Most of the major banks are SBA approved. But the government also issued guidance in early April, or I think it was, or maybe part of the CARES package, that said any FDIC insured bank is now a PPP SBA approved lender, but the bank still had to apply to get that certification. So it's important to just talk to your local bank or whichever bank you use and find out if they are an approved SBA lender. And if they are, then you should be able to apply through them for the PPP loan. If they're not, you can ask them if they're applying or in the process. And if they say no, then go look for another bank and talk to them, because there's a lot of smaller banks, regional banks that are willing to take on new clients. I mean, there's always some banks are overwhelmed with the amount of applications, so they're not taking on new clients. So you just have to get on the horn and talk to a few banks and see who you can apply to, and just get those communications out.
Great. Let's see. This one, we are set up as a corporation and applied for PPP and economic disaster loans. The owner applied for unemployment because they are not working. Will this cause a problem if the PPP is approved? No unemployment payments have been made.
I think that this was I tried to answer this originally, but it's just basically the corporation is a separate entity. So the corporation is applying for the PPP. The owners and the employees can apply for, unemployment themselves. And so that's separate.
Okay. And this looks employment related, but I think this is for you too. Kellen, I let off 8 part-time employees. Do they all need to be hired back, or do I need to hire back their full-time equivalent to qualify for the forgiveness portion of the PPP?
Right. So if you laid off employees, can you hire new employees to cover that? I haven't seen guidance on whether you can replace them with FTEs. My understanding, based on what the Treasury Department released, was that you're supposed to be hiring back the people that lost their jobs, because that served the purpose of the legislation itself, which was to ensure people weren't losing their jobs. I understand that in the grand statistical scheme, if you're hiring someone else that didn't have a job, that you still might be contributing to the economy. But I think the purpose was to hire back the same people that lost them, that lost the jobs in the first place. So I would focus on that, but I just want to pin that and say that's a great question. It's a very specific question, and I'd like to look into that a little bit further, and then we can make sure to kind of get an answer back to the community of people that are attending this.
Yeah, good point. I know that we went through this process with some of our clients with the actual applications, and you probably know this, but they take a snapshot of your payroll during a specific given time, and it's a very specific period. And as with other SBA loans, they will audit it. So later, when it comes time to determine what part of the loan is forgivable and what part is not, the SBA and the government retain the right to audit the financials and ask questions. So I would hate to say that you could just hire other part-time employers or full-time employees and replace those employees. A lot of the legislation and the loan enactment language is not specific. A lot of it's very general. So some of these guidelines are a little bit hard for us to navigate to because it's a brand new thing. But
Right.
I would venture to say they're going to be auditing that. So that's
Right.
something to be determined.
And just one point is also from a business perspective, from the business owner's perspective, they, you might have had to lay them off and now they've decided to go work somewhere else or move away, and you might not even be able to hire them back. And should that preclude you from being able to get loans and to hire new people? Common sense says no, but the law doesn't always necessarily reflect common sense because it was written pretty quickly. And so we kind of wait for that continuing guidance. So I'll look through, see if there is guidance on this issue. And if there's not, we'll just have to kind of defer until there is.
Okay, thank you. And then the next question is the self-employed applicant for PPP money. How does a self-employed person prove the wages were paid to qualify for the forgiveness of that portion of the debt in the future? Is that as straightforward as a self-employed person writing a check from him or herself?
Right.
I can answer the first part of this, and Kellen, you can weigh in if you'd like. And this is where it gets a little bit difficult because again, we're not giving legal advice. If you were in our office, we'd be asking a lot of questions, but when you're self-employed, you can pay yourself in different ways. You can pay yourself payroll, you can pay yourself distribution dividends, you can pay yourself dividends, but the state and the federal government like to see self-employed people take a salary. One, it generates revenue for the state and federal government, but also they do like to see that you're generating income on a salary like you would if you were hiring people. So if you're paid by salary, that's how they determine it. They're going to take your salary, right? They're going to take your payroll records. They're going to look at your payroll payments, your payroll tax payments and things like that. If you're paid by a distribution, then they're going to look at things like your 540ES or your 1040ES or whatever it is that you file with the government to show that you were paid salary. But the goal of the loan and the goal of the actual deferment or forgiveness is to keep people employed and keep businesses open and keep the economy driven. So what they're really looking for is whether you kept your employees under your self-employed company covered. And that's, I think, the goal of it, and that'll be what's focused on more. Kellen, do you have more on that one?
Yeah, the only thing I would say is that, record keeping and accounting is important, and you couldn't like write a check now, but you could kind of look back and say like, can we prepare records to support what I would have been paid? Or you can look at, if you're not taking that, your Schedule C, and they look at the net income and they use that in the application to determine the amount that they're going to loan to you based on your payroll. And I think that after that, we have a question which is about landlords and
Yes.
evictions.
Yeah, and it starts off, if a landlord threatens eviction, which I believe is illegal, what is the tenant's option? I think that there's just a moratorium on evictions. If you default on a lease obligation under contract, depending on that contract and their rights and remedies, it's not necessarily illegal. There's just a moratorium on evictions right now in specific cities, but I'll let Kellen speak to that one.
No, you're absolutely right, Angela. There were, at a federal or at a state level, Gavin Newsom issued executive orders allowing counties to individually restrict commercial evictions. And he made the executive order also restricted all moratorium on all residential evictions. Cities like San Francisco have a moratorium on commercial evictions. I don't think Contra Costa does yet. But that doesn't excuse the obligation to pay rent or any of the obligations in the lease contract. That just means that as of now, they're not even allowing the courts to hold sessions for unlawful detainers, is how you evict someone, is with an unlawful detainer. So the courts aren't doing that right now. So it's not illegal. There's just not a process for them to follow. There's not a judicial process for them to effectuate an eviction. but they could still follow up with requesting, the money that is owed thereafter.
And you also have to be very careful. The courts, some of the courts in different counties are closed as well, but it doesn't mean that when they're not open, there'll be a civil complaint filed for damages and things like that. So you really do need to work with your landlord and try to get that the rent either abated, built into the back end of the lease, or some sort of forgiveness of a portion of it. But it all needs to be in writing, and it needs to be signed by your landlord. And you need to really take a lot of self-help measures, hopefully with the guidance of an attorney. The next one is, if we have a 3-member LLC without payroll and just guaranteed payments, what documents do we need to provide to apply for the PPP loan? So I'll take that one. So a 3-member LLC, that's a limited liability company treated much like a corporation for tax purposes, and affording the same level of personal protection with regard to risk. That's a very complex question. It's not something I could answer in the webinar because the documentation that you need to provide to support the PPP loan is voluminous. And I think maybe they're asking, because they're explaining how they're paid, they're asking if a portion of it would be forgiven, if I can read into this, because they don't have payroll. And again, that's a little bit outside the purview of this webinar, but we'd be happy to talk to you. The information about our firm is at the bottom of, I think, the first page, but it's info@delahousselaw.com or info@DLHAlaw.com. Let's see, it is my understanding from an attorney that furlough is not applicable in California. There is no such thing. Are you aware of this, Lindsay? That's not exactly accurate, but I'll let Lindsay answer that.
Hi, yes. Actually, the term furlough has been used throughout California for years. Governor Schwarzenegger, about a decade ago, used it when he had to implement furloughs for state workers. Recently, Disneyland, in Southern California, they had to furlough a significant amount of their employees, but they made it clear that they were maintaining those employees' healthcare benefits for them during the furlough period. So essentially, under the law,
Looks like we
I
lost
think
her.
Lindsay froze.
All right, maybe we should go on to the next question. We'll get her back.
Okay, I'll go on to the next question, hopefully. Let's see. Let's do this one. If commercial landlord is not cooperating and not willing to reduce or abate rent, how soon can they try to evict? I think we kind of answered that. Oh, there's Lindsay. Sorry.
I don't,
That's
yeah.
okay.
Where did I get cut off?
Right after Disneyland.
Oh, okay. So under the law, essentially, if the employer is terminating a furlough, that it's basically saying, it's my intention that I want to keep this person as an employee and I'd like to bring them back. And oftentimes they're keeping them as employed and they're paying their healthcare benefits, but that employee is still eligible to apply for unemployment benefits just as if they were laid off. That employee and they're eligible to receive that up until they get a return to work date. Now, if the furlough is within, and they are given a return to work date within the same pay period, then that employee is not considered terminated as they would be if they were laid off. And so that's why the Labor Commissioner has provided guidance stating that employers don't have to pay them out all of their vacation time if it's only going to be that short of a furlough period. So really, furlough is just more of a term showing the employer's intention, but you really have to look at the specifically at the duration and the context of the layoff or furlough to determine what you need to do to comply with California law.
Thank you. Let's see. Some of these are questions that are a little bit particular. Let's see, that was very clear, Kellen, thank you. Our property is managed by a real estate management person. I have written to him and he said he would have to defer to the owners of the property. Should I insist on direct contact with the owner or let the real estate management person continue to be the go-between? Sorry for all the questions. Kellen, do you want to take that one?
Unmute. Sure. Right. So this is more of it's like a logistical issue dealing with the real estate management, to the extent that they're willing to work with you and the owner, but your contract is with the owner of the property. Although they, a lot of times they hire management companies so that they don't have to deal with kind of the minutia of everyday management. However, again, your contract is with that owner. So you should just be very clear that if you are requesting certain mechanisms or abatement or deferment, that you're doing so and you're providing like proper notice. In your lease, there's going to be a notice section, and you want to make sure that even whatever you send to the management company, you also send pursuant to that notice section. And that's just really important because that's going to start the clock ticking on things like where there are moratoriums or the courts are closed, like in Contra Costa County, at least I think through April, they're not going to be processing these. And I think there's a certain commercial tenants and residential ones have, there's a moratorium, but you have to provide notice. You have to tie the notice to COVID and your loss of income, and it's only to not pay rent. So those things you have to like make sure that you're sending the notice to the proper person in your lease agreement and then saying the proper things. And so that's just all kind of like, it's important to be very specific about that and make sure that you're following the rules, because if you don't, for instance, if you wait until you're supposed to give 7 days notice, and if you wait until the day before rent's due and then you send them an email, well, you didn't effectuate notice properly. And that means that you don't get the benefit of the legislation that was passed in Contra Costa County to prevent commercial moratoriums, or not to prevent commercial evictions. So it's important to follow those rules.
Good. So I think at this point we're about out of time. I've tried to answer some of the questions in the chat room, or not the chat room, in the Q&A section by recommending that you email the firm directly. We can help you a little bit more because some of them were getting a little bit specific. But with that, I can turn it back over to John.
Excellent. Well, thank you very much, team. I mean, I think I have to speak on behalf of all of the chamber members and all of our guests that this is just an invaluable session. I mean, how often do we have a chance to listen to the experts kind of deal with it? And I think you really handled it well. And of course, I think you said multiple times, right? There's a lot of not much specificity on a lot of these particular rules, and we're all kind of learning as we go along. So we really appreciate that. And for those of you on the call, this is being recorded, and we will send out a link to the recording if you want to kind of refresh it. I know we had a lot of facts being thrown at us, so it's important I think, if you want to listen to it again or share that with other chamber members, you certainly. So great. So again, I thank you very much, everybody. Appreciate you taking your lunch hour to speak to all of us, and it was a very informative session.
Thanks for having us.
All right. Thanks a lot. Take care, everybody.
Be safe, everyone.
All right. Bye-bye.
Bye. Thank you, everyone.